what does that mean though? Like if I'm in probate and I'm trying to settle, let's say my uncle's estate, can I get at his assets?
With leave of court, yes. Once you are appointed and receive the letters of office from the court, which is basically a certified document, which tells everybody that you are, in fact, the representative of this person's estate, legally, and you can then, find out what the assets are, disclose those to the court, notify the heirs, and then ask for those assets to be distributed pursuant to either the will or the laws of intestacy.
Okay.
And welcome into Protect and Grow Chicagoland Retirement with Chicagoland's certified financial planning professional, Tim Stearns, CFP, here with a common sense approach to your money, your finance, your investment, and your retirement planning. If you've got questions or concerns, as always, ladies and gentlemen, you are welcome to bring those up, discuss them with an experienced qualified professional, individually and personally. That's the resource brought to you on the program and by Tim Stearns, CFP. Just give a call, 800-640-2256. That's 800-640-2256. Or you can go online to the newly revamped, new and improved website, tjstearns.com. Lots of resources available there for you, tjstearns.com. And Tim, on today's program, a little deviation from our normal routine, we're going to bring on one of your professional resources. It is a team planning approach there at TJ Stearns Inc. And talk about the correlation, the integration, the interdependence of the financial planning, the investments, the money side, and the legal planning, estate planning that must complement each other.
Yeah, Peter. So I've worked with a guy named Don Cosley forever. We've known each other since we were children. But basically, what I wanted to do is I've been asked so many different estate planning questions that I felt like we should do a actual show about it and have Don on here. And so I'd like to bring him on, and he can kind of answer some of the questions that we go through on a daily basis at TJ Stearns, and he helps us solve them.
Absolutely. Well, we've got Don standing by, and we'll bring him on in just a second. But Tim, from the financial perspective, it is essential to have your plan coordinated from a financial, a legal, and we'll probably talk about this one into the future and throughout this program, a tax standpoint. And even if you have the best individual professionals in each one of those areas, if they're not coordinating on your behalf, you're probably not getting the most out of your plan.
I agree. And if you're going to default to probate and those types of things, you're defaulting to what the government's wishes will be. And no one wants that.
Yep. Well, I guess then it is time and an important conversation, certainly, as we bring on Don Cosley to talk a little bit about the integration of the financial and the legal and estate planning aspects and some of the important questions that are on proactive savers, investors, and planners' minds. So let's welcome in Don Cosley.
All right, Don, without further ado, I wanted to bring you on the show. I appreciate you coming on here. As you know, you've helped so many of my clients with their estate planning issues and that type of thing. So I want to keep it kind of basic, but we've been asked more and more every day about, what the Secure Act did to the, different, legacy plays that we're doing with our clients. But let's just start out real simple. Do you need a will? Does everybody need a will?
Well, everyone doesn't need a will, but it's advisable that they do have a will, because a will is a primary document for transferring your assets or belongings on your death to whomever you want to leave those assets to. So it's basically an expression of your intent of who you want to get and how much you want them to receive. So it's highly recommended that one have a will to transfer those assets.
Okay. And then Don, a subject that we've heard a lot, during my CFP classes and that type of thing was intestate. And what does that mean exactly?
So intestate is when someone dies and they have not executed a will. So
Okay.
what happens is then, assuming their assets are going to go through probate court, the laws of intestacy by the state of Illinois will determine who gets the assets and what percentage.
Okay, got it. All right. So that leads me another question that, unfortunately we've had people, after the fact call me to ask me about what they should do because someone didn't have a will. So what is probate, and how much does probate typically cost in the state of Illinois?
So probate is the division of the circuit court of the county in which the person resides and that administers their estate, right? So the probate process generally in Illinois will take 6 to 12 months. So the assets will be tied up for that period of time. The cost is generally, the average cost is around $10,000 to $12,000 in attorney fees, court costs, and bond costs.
And you typically, what does that mean though? Like if I'm in probate and I'm trying to settle, let's say my uncle's estate, can I get at his assets?
With leave of court, yes. Once you are appointed and receive the letters of office from the court, which is basically a certified document, which tells everybody that you are, in fact, the representative of this person's estate legally, and you can then, find out what the assets are, disclose those to the court, notify the heirs, and then ask for those assets to be distributed pursuant to either the will or the laws of intestacy.
Okay. And is it true that I've heard in Cook County it could take even a couple of years to settle with probate? Is that true?
If there's a contest or someone objecting to a certain asset being distributed or percentage, yes, obviously those can take longer, just like any civil litigation, divorce case, when there's objections and contests, it's going to take longer.
Got it. All right. So break it down for me here. Like, why would I want a trust or a will, or do I need both?
So generally, everyone needs at least a will. That would be the basic, not the platinum package, but the basic package, right?
Okay.
So in Illinois, if you have an estate in your name alone without a beneficiary designated in excess of $100,000, right? So that estate or that asset will go through the probate process unless you have set up a trust and you've designated or titled that asset in the name of the trust. So if you do it properly and your assets either have beneficiaries or are in a trust, when you pass away, your estate value will be nothing or less than $100,000, which means you can avoid probate court.
Got it. Okay. So, and then, we always hear about revocable trust versus an irrevocable trust. What would you say is the difference there?
So simply put, a revocable trust is a document that someone can amend, modify, alter, or change, right? So, whether it be the beneficiaries, the successor trustees, things of that nature, like the percentages. Well, people can make amendments, and they do all the time, to their trust. An irrevocable trust cannot be altered, modified at any time by the trustee.
Hey, Don, I don't know if you can put an exact figure on this, but in your experience, what percentage of people are able to successfully bypass that, what sounds like could be an arduous probate process?
Well, everyone can do it, right? I don't know if there's percentages on people that do or don't, but think of it this way. If you have assets that you can have beneficiaries tied to, life insurance, IRAs, 401ks, even a savings account or checking account, you can have a beneficiary on. So those are going to pass directly to the beneficiaries as you've set it up with that company, right? The main asset that people cannot do that with is real estate. So generally, the real estate will go through probate because most of the times it's, at least around here, valued at more than $100,000. Now, if a husband and wife own it together, husband dies, the wife now owns the property, right? So that's not going to go through probate court, right? But if they both pass, or one person that owns it passes away, and they have not put their real estate in the trust, that asset will go through probate, which is probably a high percentage of most probate estates are involving real estate that has not been put in a trust.
Don, I have heard it put in such a way, because that probate process can be contended, contested, and disputed, that probate is essentially a lawsuit that you place on your family on behalf of your creditors after your death. Is in your opinion, is that an accurate description of the process?
Well, I think the term lawsuit has a connotation of you're suing somebody, right, for a cause of action that they have done to you, such as a breach of contract, some sort of tort like personal injury. So it wouldn't really, it is a case. It's legally filed with the court. So it's similar in that regard. There's a judge that's appointed. You do have to notify the heirs, and you have an affidavit of heirship that you publish, and you have to notify them that this has been opened, and it is open to creditors to file claims against the estate. So in that regard, you're partially right, partially, I would say wrong, but just it's not really a suit against somebody. It's opening a process to then have the court and resolve any differences, or hopefully follow the expressed intent of the testator, right, to administer their estate like they wanted it.
But if there are assets there, perhaps better to avoid it if you can.
Well, anytime there's an ability of people to challenge something, open up the estate, meaning, you have a creditor that might file a claim and get paid. Obviously, it ties up potentially the real estate. You can't sell it right away like you would if it were in a trust. You have to post a bond for the value of the estate. And obviously, just being as a lawyer, any court process is going to take long, right? No court process is quick and simple, right? They want to make sure it's slow and sure. So anytime you can avoid, and I'll say this as a lawyer, avoid lawyers and courts, it's not a bad idea.
Well, once again, we are talking with Tim Stearns, CFP, founder of TJ Stearns Inc., of course, host of the Protect and Grow weekly program, as well as Don Cosley, consulting on the coordination between the financial and the legal and estate planning, and the necessity to coordinate those. And if you've got questions or concerns, ladies and gentlemen, if you've not addressed any issues that are being brought up, or if you've got issues of your own you would like to address, do feel free to be in touch. Give a call, 800-640-2256. That's 800-640-2256, 800-640-2256. I think it's important that everybody address these issues, Tim, and so many have left it unaddressed.
Well, and Don and I have run into this left and right with people who just didn't plan ahead. And the last thing you want to do is default to the government, telling you what's going to happen. And like Don just said, taking forever to get a state settled is not something that I would want on anyone. So let's get back to a couple other questions I had, Don. Once people have a living trust, let's say, what do people do with their real estate on that? I hear all the time where someone executes a trust, but they didn't, put the real estate into the trust. What does that all go into that?
Sure. Well, when I set up a trust, we make sure that we deed the real estate directly into the trust right away, because it's a common thing. In fact, I met with someone Monday, and she had set up a trust a while ago, let's say 15 years ago. And she sold her house. She bought a new house. When she bought her new house, she just either forgot or didn't take title in the name of the trust. So she came in to update the trust. And I said, well, we're going to check to make sure your new house, which is really not new, I think she's been there for probably 5 or 6 years, right? Jeez. Is properly in your trust. Because what's the point of having this trust set up while you have this real estate dangling out there in your own name, right? So in fact, we checked, and yeah, she did not put it in the trust. So we are doing, as we're updating and doing a modification of her trust, we're also going to deed it into the trust. So a key component is funding the trust, right? You take the time, you pay the money, you set up the trust, you do the documents, you pay the lawyer. And then the last part is putting the property in the trust. And a lot of people don't do it. They forget about it. Life goes on and years pass and they've not done it. So it's really important to do it right away. My office, we make sure we do that right away. When they sign the trust, they sign the deed, and then we record it right away.
So that being said, I mean, let's say I have a trust, I have a will and that type of thing. When do you think I should review that? Like how many years should be between since I executed it?
I think, some people might say like yearly or every couple of years. That's probably not practical, right? It's always longer than people think, but I would say every 5 to 10 years, unless there's been a significant life event, someone passes away, there's a divorce or some other, major life event that would require you to do it. I would say commonly, I see most people come in when their parents have passed away and it's kind of in the front and center of their mind because they've dealt with their estate,
Sure.
to get their own in affairs in order, or every kids age out, and they want to make their kids their trustees instead of their parents. So I would say every 5 to 10 years, people generally come in and want to review. Sometimes I look at documents that are 15, 20 years old. Some people come in and they're in their 70s and they haven't done anything.
As you and I have both seen. The other thing I wanted to understand a little bit better is what is a property / financial powers of attorney? What exactly does that do for me?
Yes. So a financial power of attorney would avoid the necessity of a guardianship potentially over someone. So a power of attorney is giving agency while you're alive. Okay. So a lot of people have the misconception that a power of attorney extends past one's life, right? So if I'm giving you my power of attorney, Tim, it's only effective while I'm alive, right? And after I die, it's no longer legally operable. However, those can be powers of attorney can be triggered in 2 events. Number one, immediately. I can give you my power of attorney immediately, right? To take care of my financial affairs. Now, it can also be more commonly triggered upon my physician certifying that I'm no longer able to manage my financial affairs, right? So if I'm incapacitated in some fashion, you can go in and manage, pay my bills, pay my taxes, do things that need to be done until I'm either no longer disabled or incapable of managing. When I'm capable of managing my affairs, I'll take it back. Or it could be like temporary, like I do a real estate closing. You don't want to go, you give me a power of attorney to execute any documents at the closing. It's really specific for that date and that issue. And then it's done. So that's basically giving someone your ability to do your financial affairs.
Got it. And just to put that out there, how many years have you been an attorney?
So this is my 30th year. I graduated and passed the bar in 1994. So 2024, time flies.
So you've seen a couple things in your time.
Yeah, I should have started my book, keeping track of all this stuff a long time ago. So now it's just all in my head.
Okay, so going back to powers of attorney, what exactly is the medical healthcare with the healthcare directive? People throw those names around a lot. Can you kind of boil that down for a layman?
Sure. So that is giving someone the ability to make your medical decisions either effective immediately or more commonly when your physician certifies that you cannot make those on your own, right? So you're in a coma, you're in you had a stroke, you can't make medical decisions or consult with the doctors and things you need to do. So I would give someone that ability to do that, and you have a directive in the healthcare power of attorney form, which basically says I want my agent to weigh the benefits and the burdens and, kind of weigh everything and do what they think is best, considering the circumstances and the likelihood of surviving or coming out of whatever, legal or medical issue that I'm experiencing at that moment. So commensurate with that, we also do HIPAA disclosures to allow the agent to consult with the doctors legally, right? To give them the ability to disclose anything that normally wouldn't be disclosed because of privacy reasons.
Documenting who can make those kind of important decisions, obviously so important. Planning ahead of time financially to cover what expenses there might be, and making sure that you document who gets what and how they should receive it. Again, that's where the coordination of the financial and the legal and estate planning comes into play. And just from this conversation, gentlemen, I think it's important for everyone, but obviously something that those with assets and wealth need to find essential, cannot be overlooked. Such a much more costly mistake if it is. And that's why, ladies and gentlemen, again, if you've got questions or concerns, just give a call. Make sure that this has been checked off your to-do list. Don't leave this as one that you procrastinate on. Get your plan put together. And of course, Tim Stearns, CFP, as well as his team of experienced qualified professionals, can help you not only create and craft and implement, but coordinate your planning from all perspectives. So give a call to get started or review your current plan. 800-640-2256. That's 800-640-2256. 800-640-2256.
Well, thanks, Don, for that. And so my other question, we have people come in here with different schools of thoughts that they want to leave. They finally have this trust, they're all excited to use it, and they want to leave their, let's say, an IRA to their trust, or to, should they leave it to individuals? Where do you fall on that, Don?
So I recommend that it go directly to the individuals.
Yep.
And the reason for that, I think, it's just simply easier for the beneficiaries to obtain directly from the IRA or whatever the plan is, by sending them a death certificate, filling out a form, and they get their percentage, right? If it goes to the trust, and the trust can be maybe the backup, but then it's kind of like, well, how do we know there hasn't been an amendment to that trust? How do we know that that is the way that the trustee wanted it, right? So there might be some review and some delay from the plan before distribution. So I just say, that would be the direct beneficiaries would be first, and the trust can be the contingent.
Got it. And I appreciate you saying that, but specifically, let's say someone really they have no children, they want to leave it to a trust. If the trust was drafted before 2020 and their retirement assets, why is it essential to get that trust reviewed today?
Well, there are some provisions in the new act so the new act presumes that a trust is irrevocable unless it explicitly states that the trust is revocable. So since most people want to do revocable trusts, you'd want to make sure that that is clear in any document that you've prepared.
Sure.
Now, the code does grandfather in old trusts, obviously, but if it's not clear in the old one and it's prior to 2020, it might presume it to be irrevocable, which means you can't change it. So certainly, now we're 4 years past, and we talked about people looking at things every 5 or 10 years. It's not a bad idea for everyone to have that reviewed by someone. And you know what? Sometimes people bring them in and there's no changes that need to be made, and usually there is, though. So
of course,
certainly something people should keep in mind.
And that leads me to another question that we've run into, where people are, they have co-executors, co-trustees. What are your thoughts on having multiple people there?
So this is how I define it to people. So we are doing these documents to avoid going to probate court. And if you appoint 2 co-trustees or co-executors and they have a dispute about what should happen, where is that dispute going to play out? But in probate court, in the place that you're trying to avoid, right?
Well said.
So don't do co's, you do one and then two.
Right.
I say, don't sweat on who's one and two. It's a burden on the person that has to do the work. It's not a crown to wear, it's a cross to bear. It's a lot of work for them. And maybe the person that doesn't get the job is actually the winner, not the actual trustee.
Well said.
Don, we talk often on the program about, from the financial perspective, how important it is to have the completed and updated legal documents and the essential nature of coordinating the financial and the legal elements. From your side, on the legal perspective, would you echo that and say that yes, that is just an important part of effective, efficient planning?
Well, it's an entire pizza, right? Everything, your financial part, your legal part. So, you can't, you don't buy a pizza and have two slices not in the pizza when it's delivered, right? So you don't get an 80% of the pizza, right? So I'm halfway through a book called, John Grisham book called Sanctuary Row. So this guy, after his divorce, acquired $24 million in assets, estranged children. He does a will, leaves it to his kids. Then the day he dies, he does a handwritten will, leaves it to his housekeeper, and then he kills himself because he has a terminal lung cancer. Okay. So in that scenario, he's obviously got the financial part down, right? He acquired tremendous wealth. But then there's a will contest because he did this handwritten will on the day that he killed himself and mailed it to who he wanted to be the lawyer for the estate. So you could imagine that you have this tremendous legal case in the small town in Mississippi, which I'm halfway through. So I can't tell you how it plays out, but
no spoiler alerts here then.
That's
good.
that's the scenario, right? You've got this estate and now you haven't taken care of the legal part properly, right? If he had just done that, because obviously now his kids are contesting his testament, his capacity to make that will, whether he was under fraud or duress or under medication and things like that. So why leave that up to chance, right? If that's
Don,
really what you want.
You bring up another point that I want to hit on real quickly here before we wrap up the program. And thank you so much for joining us and providing your perspective. But you mentioned the amount of money as the example in that book. And Tim has talked often about how there is as tax laws stand today, the real potential for these currently very high estate tax limits to be reduced into the future. Is it your recommendation that those with those kind of assets get ahead and get to getting on with their estate planning now, and that there might be some advantage to doing so?
Absolutely. I mean, things are changing all the time. You want to stay ahead of the game. You want to have, professionals, whether it be legal, financial, working on your matter. So absolutely, that's extremely important. And if people have assets and they have a plan, they need to execute that.
Absolutely, Don. That's a great point. I just want to say thanks again, Don. I've worked with you forever on these different issues that come in to our office, and you're always great with our clients. So I appreciate your friendship, and then of course, all that you do for my clients.
Thank you. I appreciate all the referrals, and I hope they've been satisfied with our services, and that keeps coming that keeps coming in, Tim. So
Amen.
Thank you much, and thanks, Peter.
Agreed.
Nice to see you today.
Absolutely, Don. I appreciate you joining us on the program, providing a little bit of a different perspective. We always appreciate it, and try to cover all perspectives for you, ladies and gentlemen. There's important angles to planning that can be seen from the financial, the legal, the tax side, and of course there are subcategories under each one of those that those respective professionals need to help you identify and then tackle and handle on your request and behest. So give a call if you'd like to get that started. Of course, Tim Stern, CFP, always makes a very special offer on the program, not only to help you put your Protect and Grow plan together or review your current plan, but again, Tim, you also have written a book solving the modern retirement riddle, and you like to get a few copies of those out into people's hands as well.
Yeah, and I'd like to say anyone out there who has $1 million or more, give us a call. We'll get the book into your hands. We have it digitally. It's on Kindle, and we also have it in hard copy. But give us a call. There's a lot of good tidbits in there to get through this financial paradigm that we're seeing nowadays. And then obviously we can help you with your estate planning with the help of Don Cosley.
All right. Well, we always appreciate the time with Tim Stern, CFP. Appreciate our special guest on today's program, providing the legal perspective, Don Cosley. Thank him very much. Thank you, Don. And of course, ladies and gentlemen, thank you for tuning in. Always important information we try to bring to you. So if you've got questions, give a call, 800-640-2256, 800-640-2256, or visit online, tjstearns.com.
Tune into Chicagoland certified financial planner Tim Stern's full radio program and visit tjstearns.com for many valuable resources, including other great episodes of Chicagoland Retirement. Be sure to subscribe.
Investment advisory services offered through Cornerstone Securities, LLC. The information presented on this program is provided for informational purposes only without warranty of accuracy, completeness, or suitability for particular purpose. This program is not intended to be and does not constitute financial, investment, legal, or tax advice. This information is general in nature, not specific enough to be construed as advice. You should not make any decision based on the information presented on this program without independent consultation with an appropriately licensed professional or competent advisor. Investment in securities or the market involves a potential risk for loss of principal. Trading, therefore, may not be suitable for all listeners. Annuity guarantees are based solely on the financial strength and claims-paying ability of the issuing company. Withdrawals or growth from annuities may be taxable as ordinary income in the year it is taken. Individuals should review contracts for specific details of the product's features and costs.